Just a moment, judges. We're waiting on counsel to join. One more moment. We have two attorneys that must have a slow connection. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Good morning, counsel. Thank you for your participation by Zoom. We had hoped that we would be live in Laramie today, but the pandemic has done that plan in, as well as the rest of the September arguments even. I think the UW students, however, are patched in by video, and so just one word to them, which is, sorry we didn't make it. Both judges who are joining me on this panel really desired to come to Laramie. It's a hot position. More judges want to do it than get to do it. And we felt happy to have won the draw, the three of us, and unfortunately didn't happen, but we're working behind the scenes to try to get back next year and keep the same panel. Just for your knowledge, Judge McHugh, who I think is marked as such, is a judge from Salt Lake City, Utah, and Judge Moritz is from Kansas, and the three of us came on the court about the same time. The reason that I'm speaking isn't because I've been a judge as long as they have. They both have extensive state court, appellate court in their background, which I did not, but instead, by happenstance, my confirmation occurred a few days or months before theirs did, weeks. So that makes me the presiding judge. We have 5 cases that we're going to hear today. Originally, we thought that we would have 6, but in one case, counsel has had a medical situation, and accordingly, we will postpone that for another day that will not be held in this sort of way, unscheduled at the moment. So we have 1 civil case and a number of criminal sentencings. And we will pick right up with the first case, which is United States versus Mar-Lopez. And the docket number is 20-1261. And I will turn to Mr. Rouse Chabot and ask if you are ready to proceed. And when you are ready, please do proceed.
Thank you, Your Honor. May it please the court, Jake Roche-Chabot for the appellant Rolando Mar-Lopez. The district court rejected the party's binding sentencing recommendation in their 11C1C plea agreement, and then imposed a 2-month increase above the party's recommended range for the express purpose of sending Mr. Mar-Lopez a clear message that the judge, not the parties, determines the sentence. In doing so, the district court plainly based the sentence on an impermissible factor. Government does not dispute that increasing a defendant's sentence because of the C1C agreement would be plainly erroneous. And for good reason. It would be wholly unrelated to the legitimate goals of sentencing and would effectively punish a defendant for availing himself of a procedural right. Rather, the disputed issue here is whether that's what the district court actually did.
Well, let me clarify. We're under plain error here, aren't we? So you've got to meet the 4 prongs of the plain error test. So
yes, Your Honor.
Assuming for a moment that we just assume for purposes of analysis that it's error, where the district court explained that the reason it was extending it 2 months was to deter Mr. Mar-Lopez from coming back to the United States and thinking he could work out a deal that would make his sentence run concurrently with anything else he had. Isn't it at least not plain that it violated the sentencing factors, that it was indeed under a sentencing factor of deterrence?
Your Honor, I think it's at least clear and obvious that simply couching a impermissible factor in terms of deterrence doesn't cure the taint of the original impermissible consideration. Now, in my opening brief, I gave the example that a district court could not say to a defendant that I want to send you a clear message that if you come back, you can never accurately predict what sentence a judge is going to give you. And so to impress upon you that message, I'm going to roll the die to give you a unpredictable sentence. That would clearly be impermissible. I don't think anybody could possibly dispute that basing a sentencing enhancement on a roll of the die would be erroneous. And simply saying that, I need you to know this in case you come back and come before another judge, that might have some incidental deterrent effect, but it doesn't cure the original plain error. And here, the original plain error is that you can't increase a defendant's sentence because they availed themselves of this 11C1C plea agreement.
Well, but you're assuming, you can read the comments of the district court and you can read them as being a permissible reason. I want to deter you from coming back again and again, having an illegal reentry. And you can do it as, I want to somehow discipline you for trying to work out a deal. And when we look at it, it's not clear. It is fair, isn't it, to say that we could look at it and say that this was a permissible deterrence consideration?
I don't think you could say that it's a permissible deterrence consideration because of the underlying impermissible consideration that it's because he entered a C1C plea agreement. There's no way around the.
Yeah, I'm not sure the court ever says this is because you entered into a C1C agreement. The court says this is because I don't want you to think that you can negotiate a sentence that will protect you from serving more time.
Right, and the only reason there's no way getting around the fact that if it were not for his seeking to bind the court with the 11C1C agreement, he would not have had to send that message. There would be no impetus for the court to increase the sentence by 2 months. So even if he didn't expressly say, I'm increasing it because you had the gall to try to bind my authority, it's still a necessary conclusion that if he had not recommended the 0 to 6 months in the binding C1C agreement, then he wouldn't have gotten that 2-month sentencing increase. That message was a direct and proximate result of his having sought out the binding plea agreement. And the way that the judge just sort of tacked on this 2-month deterrent enhancement was also impermissible because it just wasn't based on a balanced consideration of the 3553A factors. That is, it's not that the length of the sentence, 6 months, the judge found inadequate. It wasn't that he said the parties have the parties agree to 6 months. I find that is inadequate. That the length of the sentence, 6 months, is a slap on the wrist that wouldn't sufficiently deter you. It was the mere fact that the parties had recommended that 6 months that the judge found it inadequate because he needed to send this message that I can't accept the parties' plea agreement or the recommended sentencing range because that wouldn't be a deterrent, which is to say that if the parties had asked for recommended 0 to 8 months in the C1C, the judge would have rejected that to send the message that to send the exact same message, and he would have received a 10-month sentence. So this increase of 2 months that the court aimed at deterrence was essentially arbitrary. It wasn't based on the length of sentence wasn't based on the careful consideration of the 3553A factors. Rather, he just tacked it on to the parties' agreement.
Are you suggesting? I'm sorry.
Please.
I was going to say, are you suggesting that the sentence imposed, which was just 2 months more than the agreement or the government suggested in the agreement, wasn't really, the court didn't intend for that 2 months to be a deterrent. What it intended for as a deterrent was that it was rejecting the plea agreement, and that it suggesting that a court could do so in the future. So the deterrent factor didn't really apply to the sentence itself. Is that what you're saying?
That's right, Your Honor. It was the deterrence was the rejection of the parties' agreement,
right,
of the sentencing range, and that sort of manifested in this 2-month enhancement, because in order to send the message, he couldn't give 6 months because that's what the parties agreed to, but he could tack on this extra 2 months. But it didn't result in a balanced consideration of the 3553A factor.
Yeah,
because it
and so the 3553A2B says that the court can determine or consider the need for the sentence imposed to afford adequate deterrence. So I think what you're suggesting is that the court never considered the need for the additional 2 months to be the deterrent. It considered its actions in imposing the sentence itself to be the deterrent, essentially. Is that, if we assume that that was error because it didn't consider the need for the sentence imposed to afford deterrence, would it be plain error, however? I mean, it was still considering deterrence in general.
Yes, Your Honor. I think it would be plain error for a couple of reasons. I mean, this court has said that that the absence of circuit precedent does not prevent the clearly erroneous application of statutory law from being plain error. So if this is clearly not encompassed within the 3553A factors, then it clearly is an impermissible factor. And the fact that this judge has done what no other district court has done before doesn't insulate it from being plainly erroneous, just because there's not a published opinion on point.
And certainly there was ad-libbing by the district court here, and you were pulling the laces tight as far as how you're interpreting what he's saying. I suspect if the district court were listening, it would say, that wasn't what I was trying to do at all. But when we talk plain error, we oftentimes do, of course, ask, is there a Supreme Court or 10th Circuit case on point? And granted, you can look to the clear statute and say that will substitute, but not often is that done. Have you seen a case like this before where there is this kind of ad-libbing on a general 3553A factor, adequate deterrence, where the court has found plain error? Or are you asking us to do something beyond what a court has done?
I don't think that I can point to a specific case like this, but I also disagree with Your Honor's characterization of what, say the district court was ad-libbing, but particularly in this case, that suggests that he revealed what he was truly thinking. I mean, he prefaced this discussion by telling the defendant essentially, like, I understand that Mr. Mar-Lopez doesn't speak English and that he has some cognitive difficulties. The lawyer had said that it takes a really long time to explain things to him, and so what the district court said was, like, essentially, I'm going to dumb this down and explain to you exactly what I'm thinking. So I think what we're getting is sort of a rare look into exactly what the judge was actually thinking, which is, if I give you this 6 months that the parties are recommending, it's not that 6 months isn't enough. I have to extend by 2 months to send you this clear message that you can't just rely on your 11C1C plea agreement, or as he put it, your lawyers can't save you from a judge. And honestly, I think that if the district court would probably agree, that's exactly what he meant, because it's what he told us. I think we assume that he means what he said.
And you almost are asking us to ignore the portions of the transcript where the district court judge very clearly says, I think you're a danger to the community. And it's important, given under the charge that happened, even though it's not the one I'm sentencing you for, I have to take that into account when we're talking about child sexual assault. And I need to do something to keep you from coming back here and putting children in this country at risk. I mean, that's there too, isn't it?
That's also there, and he did have some general discussion, but I'm not asking you to ignore that. I'm asking you to take the judge at his word when he says, when he concludes the discussion of explaining why. So he says, so I'm imposing a sentence of 8 months, and you might, to the defendant, you might think all of this for 2 months, and let me tell you exactly why I went 2 months above the party's recommended range. And it was because I need to send you this clear message. And then he concludes that by saying, so I'm only increasing what the lawyers were debating by 2. So he's making it very explicit that the sole reason he's going 2 months above the party's recommendation is to send this clear message that I don't have to follow it. And no other judge, if you come back, has to follow it either.
Well, but then he ends it. He doesn't stop there. He goes on and he says, so there is a risk to the public if you come back. There is a hell of a risk to you if you come back, which is, I'm balancing both things. I want you to understand there's a risk to you if you come back, and it's not something that you can negotiate around. And there's also a risk to the public because of the underlying crime. And so on a plain error analysis, do we ignore the legitimate basis here and say the whole thing gets thrown out? We presume that it's error and it's plain because there's a component of his reasoning that's questionable.
I think that where there is this very explicit component of his reasoning that is impermissible, then yes, then it taints the entire sentence. And I would just ask the court to take the judge at his word when he expressly stated the reason for the 2-month increase. And if I may, I would like to reserve the remaining time for rebuttal.
Very well.
Thank you.
May it please the court, Michael Johnson for the United States. This court should affirm the district court's sentencing decision because Mar-Lopez has failed to satisfy the 4-part plain error test. First, the district court did not err here. Mr. Mar-Lopez's position is that the district court misapplied the law. That is an inaccurate reading of what the district court actually said. The district court never explicitly said it was punishing him for entering into the C1C agreement. It never said that its sentence was based on the C1C agreement. Viewing the district court's statements both individually and collectively, and considering the record as a whole, the sentencing transcript reflects that the district court statements primarily focused on deterring Mar-Lopez from illegally re-entering the country. He had previously re-entered the United States 4 times. This is the record, volume 3 at page 7, paragraphs 11 to 22. 4 previous times illegally re-entering. The district court reiterated several times that deterrence was a significant factor motivating its sentencing decision. This is the record at pages 111 to 112 of volume 4.
Let me interrupt you for just a minute, if I may. The court says it doesn't specifically cite 11C1C, but it says, I want to be clear to you that if you come back, you should not believe that you can have your lawyer work it out with the government lawyer, and whatever gets worked out between the lawyers is going to be good enough. I mean, that seems like a pretty clear focus on not wanting him to rely on the possibility of an 11C1C agreement, doesn't it?
Respectfully, Your Honor, it was not focused solely on the 11C1C agreement. The purpose was disabusing Mr. Mar-Lopez of the belief that he could control his sentence, and by the court's main interest was in deterring him from illegally re-entering again, and by sentencing him as the court did, the court's focus was on deterring him so that he wouldn't be of the notion that he could again illegally re-enter and then obtain a sentence that he could control through a C1C agreement.
Well, counsel, I don't disagree with you that the court made it pretty clear that its reasons behind rejecting the plea agreement and imposing a different sentence was because it wanted to deter. My problem is, how does that intent to deter, how does that correspond with the actual 3553A2B, which says that the court can consider the need for the sentence imposed, in this case, that's the 8 months, right, to afford adequate deterrence. Can you point me anywhere in that pretty lengthy transcript where the district court recognized that the sentence it was imposing, the 8 months versus the 6 months that they had agreed to, or the government agreed to, would somehow be what was affording adequate deterrence? I think it made it very clear that wasn't the point. You see what I'm saying? It's the sentence itself. It's allowed to consider whether the sentence itself will deter future conduct. But that's not what it did here. It considered another basis for deterrence, which is, I'm going to let you know that you shouldn't enter into an 11C1C agreement in the future because some judge might ignore it. That's the basis for its deterrence. Does that make sense? Not the sentence itself?
Your Honor, if I understand your question, the court did state several times the actual message that the court wanted to convey. And that
not with the sentence. It never said that. In fact, it said just the opposite. It basically said, I realize this is only 2 months, but that's not my point. My point is, so you'll know that you can't get away with this basically in the future. Don't come back and think you're going to get an 11C1C agreement. So it recognized that its 2-month increase was not about deterrence. And that's the only thing that the 3553A2B allows the court to consider, is whether the sentence it imposes, the 2 months increase, will deter future conduct.
The court did say,
and that's not what happened here.
The court did say at page 113 of volume 4 of the record, quote, I am giving an 8-month sentence due to the seriousness of the risk that is faced by the public were he to return. The court specifically said that, and that indicates that the court's purpose in the 8-month sentence was to deter his return and to protect the public due to the seriousness of the risk if he were to again illegally re-enter.
I agree it said that in its conclusion, but it made very clear, I think, as Appellant's counsel has said, that you may be wondering, what's all this fuss about for only 2 months? Why would I do this for only 2 months? Well, here's why I'm doing this. I'm doing this so you will know. If you come back, don't think you're going to enter into an 11C1C and get a shorter sentence because some judge might just throw the book at you. It made it very clear that it wasn't about the 2 months. In fact, it said, yeah, I know that's not much, but that's not my point. My point is this. And I'm asking you, other than that last line where it sums everything up, I don't see anywhere where it suggested that that's difference between 6 and 8 months was going to be a deterrent factor here.
Your Honor, pages 111 and 112 of the record, as well as pages 92, 93, and 113 of the record indicate that the judge was sentencing him to 8 months to deter him. The court's interest in deterrence is related to the court's interest in disabusing him of the idea that he could control his sentence in a future C1C. The deterrence is related to the court's statement that he couldn't control his sentence. The court essentially said, I don't want you to, again, illegally re-enter because you think you can get a deal. The court was essentially saying, I want you to understand that a future judge is going to be the one who's going to sentence you if you legally re-enter again.
Right, I get all that. I get all that. I understand. I think that's exactly, I think the judge made it very clear what his intent was, and that's my point. It didn't seem to be about the length of the sentence imposed. It's about the fact that the judge, not the parties, decide what the sentence is. And that was the deterrent effect in this case, not the sentence itself.
Your Honor, the court initially indicated why it was rejecting the 11C1C agreement. And this is at volume 4, pages 71 and 81 of the record. The court indicated it was rejecting the C1C because the court said, I'm not going to be bound by the limited options I'm presented with. And the court at page 71 said, I'm not going to restrict myself to a range of 0 to 6 months of additional time. So the court explained why it was rejecting the C1C. It wasn't going to limit itself to 0 to 6 months. It didn't indicate that it was rejecting the C1C simply because the parties had entered into the C1C agreement. The court's later decision to sentence him to 8 months was to deter him of the notion that he could control a sentence before a future judge.
Is that proper? I would understand your argument better if you were saying the extra 2 months of consecutive time was to make him rethink it when he is in Mexico and deciding whether he wants to come across the border. But to say, to rethink that the judge is going to operate in a certain way, that's deterrence. I don't really follow that. Why couldn't he have just deterred by imposing 21 months within the guideline consecutively?
Well, the court viewed a 21 months consecutive sentence as not appropriate under the circumstances, that wasn't necessary to deter the defendant from illegally reentering again.
Does that matter? Does it matter that the court could have awarded or imposed a 21-month consecutive sentence within the guidelines, and all in the name of deterrence, and pretty good deterrence too? We wouldn't be arguing whether that was deterrence or not if you're serving that much extra time. That if the court could do that, it surely can do what it did here, which is less.
If the court properly weighed the 3553A factors and determined that a lengthy sentence would not be appropriate, and the court did not want to sentence the defendant based on his prior child sexual abuse convictions. The court was focusing on sentencing him for the conviction here, which was illegally reentering the United States. The court, if I could just address Judge McHugh's comments during Mr. Rochebeau's argument, the court's statements here can be read as suggesting deterrence. I don't think that the parties dispute that, given the multiple instances in the record where the court mentions deterrence as a significant factor in its decision. But it's not absolutely clear to this court that, in fact, the district court was punishing him or setting the 8-month sentence solely as a rejection of the C1C agreement. It's not plain or obvious or unambiguous. And so even if this court were to find that the first two factors of the plain error test had been met, Mr. Mar-Lopez cannot satisfy the third or the fourth factors in the plain error test. He can't show that the error was plain. He can't satisfy the second factor. He can't show that the error was plain, that it's unambiguous, or that the law plainly prohibits the error. So he can't show that it was plain or unambiguous under the second part of the test. He can't satisfy the third or the fourth parts of the test either. He can't show a reasonable probability that, but for the error, the outcome of the proceedings would have been different. That's the third part. Or the fourth part.
If let me interrupt you for a minute. If we say the error was extending it 2 months for the sole purpose of doing something different than the 11C1C agreement, and we say that's error, and we find it's plain, if he hadn't committed that error, I think there's a reasonable probability the court would have just accepted the 11C1C.
I disagree, Your Honor.
I'm challenging you on prong 3.
Right, I understand. I disagree, and that's because the court stated why it was rejecting the C1C, and this again is at volume 4 of the record, pages 71 and 81. The court said it didn't want to be limited to that option. It didn't want to restrict itself to the range of 0 to 6 months. That was at the first sentencing hearing, and then at the continued sentencing hearing after that time, then the court issued its ultimate sentence. So the court had already indicated that it wasn't going to be restricted to the limited options in the C1C, and it was rejecting the C1C. And so therefore, if for this court to find that the third or the fourth prongs would be met, the district court would essentially be back to sentencing within approximately 0 to 6 months, and the court had already rejected that. So the court's statements at the first sentencing hearing show that the defendant cannot satisfy the third or the fourth prongs of the plain error test. I'm happy to answer any other questions that the court may have. Thank you. We ask that the sentence be affirmed.
Thank you. Counsel.
Thank you, Your Honors. I submit that it is clear and obvious that the 2-month enhancement was based solely on this, rejection of the plea agreement to send that clear message, as the district court stated. But even if, as counsel has argued, that the goal of deterrence, as he certainly talks about throughout, also played some part in that. That doesn't mean that the impermissible consideration was still, all we have to show is that was, there's a reasonable probability that was that he would have received a different sentence. So if there's a reasonable probability that 2-month increase was based on this impermissible consideration, that's all Mr. Mar-Lopez needs to show. I submit he can show a lot more than that.
Can I ask, the court starts out its presentment of the sentence by saying, I'm mindful of the fact that I am required by law to impose a sentence which is sufficient but not greater than necessary to achieve the purposes of sentencing as described in 18 U.S.C. 3553. And then it goes on to announce the 8 months. It seems to me in our case law, when the court does that, we typically take the court at its word and say that it did exactly what it said it was doing, which was trying to find a sentence that was within those factors. I guess my problem is when you have this these statements on the record, you're asking us to ignore all the ones that are permissible reasons and to focus on the one that you say is impermissible and to say that it is plain without any case law that's ever said that. And I'm struggling with that.
Your Honor, I see that I'm out of time, but if I could just briefly respond. You're absolutely right. At the beginning, that he does say at the outset that I'm mindful of this and does give sort of a rote recitation of what the purpose of sentencing is. But it's his later comments where he distills exactly what he's doing in the most simple terms he reveals that it's not solely based on proper consideration of the 3553A factors. And rather than Mr. Mar-Lopez having to prove that the impermissible, that the error was the sole basis of the sentence, it's just the opposite. If the sentence was based in part on this impermissible factor, then that is enough to show that there was a plain error that reasonably affected, or that there's a reasonable probability that without that impermissible consideration, there would have been a lesser sentence. Thank you, Your Honors, and I'd ask to remand for resentence.
Thank you, counsel, for your helpful arguments. The case is submitted. The next case up is United States versus Wilson. It is docket 20-1324. Counsel, please proceed when you're ready.
Thank you. May it please the court. My name is Meredith Esser. I'm arguing this case on behalf of Mr. Wilson. Mr. Wilson's case should be remanded because the district court erroneously relied on the policy statement, sentencing guideline 1B113. And we know this because it explicitly said so in its order denying Mr. Wilson's compassionate release motion. After this court's precedents in McGee and Mau, this case should be remanded because it's clear that the district court used the wrong analysis when it was considering Mr. Wilson's motion. Specifically, the order states that the district court made its decision after considering the 3553A factors and the applicable policy statements issued by the Sentencing Commission, which, as we know, no longer apply to defendant filed motions for compassionate release.
Let me, first of all, we're under plain error here, aren't we?
Yes, we argued plain error in the reply brief.
Okay. Looking at your argument that the court impermissibly relied on 1B1.13, I'm struggling with prong 3 because the court also says that under the 3553A factors, I would have done the same thing.
I don't want to parse the language of the order, but I don't necessarily think that's exactly what the order says. I think that, and I just want to back up for a second because I think that the crux of this case actually is about the dangerousness finding that the district court made. So as the government argued below, the government argued for a separate finding of dangerousness, which the court did make under the previous version of the, or under the applicable policy statements, which are no longer applicable. And it quoted the government's analysis of that dangerousness prong. And I think in terms of the 3553A analysis, if the court had realized that it was not required to make that specific dangerousness prong, which triggered the denial or could have independently triggered the denial, it may have weighted the 3553A factors differently. So in other words, the finding of dangerousness could have been an independent basis for denial of the motion, but it also could have affected the 3553A analysis. And there's just no way to know whether or not that occurred here based on what the district court wrote in its order. In addition to that, I think I quoted—
Counsel, can I interrupt you there? Sorry. Don't we know, though, from the district court's order that it specifically weighed the 3553A factors? It appears separately because it said the 3553 factors weigh against early release, and then it specifically mentions that a drastic reduction in a sentence wouldn't reflect the seriousness of the instant offense or promote respect for the law. It doesn't go back to its prior factor that it considered the dangerousness issue and the finding it made. It doesn't say anything about that. It says it considered the 3553 factors and it mentions why they weigh against. Why would we assume somehow that second factor consideration carried over into the third factor analysis?
Because I think it was such a strong part of the briefing, and I think there was conflicting record evidence on the dangerousness, as the defendant pointed out.
I agree there was conflicting evidence, but the court made that finding separately. And we have said now in McGee and Mau that the 3553A factor, that third factor all by itself, that third bit of analysis can all by itself support the denial of the motion. So I'm struggling to see why we wouldn't assume that that's what happened.
Just
here,
to go back to the language of the order, although the government was arguing that the dangerousness factor could have itself been dispositive, the actual order says that the history and circumstances of the instant offense suggest that he's a danger to the community. So the court didn't actually make a specific finding on that issue, although I think it was looking at the policy statement, and in another part of the order, it said that it was looking at the policy statement.
Is there anything wrong with looking at it? All that the court says in this very short order, the introduction is, after considering the applicable factors in the 3553A and the applicable policy statements, is it your position that our case law in the year since that order was issued bars a court from even looking at 1B 1.13, or instead that it bars the court from ruling that it is bound by that? In other words, the considerations in 1B 1.13 could be very well valid considerations so long as the district court doesn't feel itself bound by that policy statement. Is that wrong?
No, I think that's right. I think a district court could look to the policy statement for guidance as long as it didn't believe that it was bound by the policy statements.
Isn't that what the order does?
No, I think that the fact that the district court said that these were applicable policy statements, I think that word applicable is quite convincing that the district court did believe the policy statements were applicable to this particular motion.
So I thought you just conceded that it's applicable in the sense that the district court can at least look at it for advice or guidance.
I mean, I think that the word applicable has a little bit more force of law than, that it would have guided the analysis. And I don't think I think on this record, just looking at how the order was laid out, and the fact that the dangerousness finding was quoting the government's briefing about dangerousness, the specific policy statement excerpt that's about dangerousness, I think it's pretty clear that the court thought that the policy statement was binding on it.
I don't get that out of reading this order. It looks to me like it made an independent finding under the 3553A factors, and I don't see anything wrong with considering dangerousness as part of the 3553 analysis, because one of the factors is protecting the public. And so in order to weigh that factor, you need to know how much of a danger this person is to the public, don't you?
Yes, but as I mentioned before, it doesn't, the district court doesn't say, oh, I'm making a finding of dangerousness as part of my 3553A analysis, because and I think our argument is that there was conflicting evidence about dangerousness. Mr. Wilson was on pretrial release for the entire time before he was incarcerated for this offense. And, I think under the old policy statement, the district court was required to make a dangerousness finding. Under the guidance today, it could be part of the 3553A analysis. In addition to that, the district
but our case law, again, we are under plain error, and our case law says now that you don't have to make the dangerousness assessment in order to deny the compassionate release under the 3553. I'm not aware of anything that says that, and you can't make it. There's nothing, even though you don't have to, there's nothing that tells the court that you can't go through, tick off all the things anyway. Is there?
I don't think that that's what the argument is. I think the argument is that the way the order is structured, it's very clear that the court was relying on the policy statement, and so it was using an incorrect legal framework when conceptualizing the motion. I don't think there's anything.
If you were right and the court felt bound by its dangerousness assessment, why didn't it stop and just say, he's a danger to the community and therefore we're done? Why walk through the whole analysis?
District courts make alternate holdings frequently.
And if it's an alternate holding and one of them is correct, you lose, right?
I mean, I just don't think that we can, I think the order is just so unclear as to what the district court was doing that it's impossible to conclude whether or not these were alternate holdings. And I think
the same problem in the prior case, which is where we have, it's unclear. The reason an objection at the trial level helps is that you can clarify it. But when you're coming to us on plain error and we can read the record as the court did not err, I have trouble saying plainly the court did err.
I mean, I do want to just point out that the defendant's briefing below noted that there was authority suggesting that there were more expansive, extraordinary, and compelling circumstances, and suggesting that there was courts that were interpreting the policy statement as inapplicable at the time. And so even though we were on plain error, we are on plain error, the legal landscape was really in flux at that time. And I mean, I'm not arguing that it's far easier to decide a case when there's an objection below, but I still think that under the third prong, there is a reasonable probability that if the district court had considered dangerousness as part of the 3553A and had weighed the dangerousness issue appropriately, and in addition to that had considered the extraordinary and compelling circumstances as part of the 3553A analysis, which it did not do, it may have come to a different conclusion as to Mr. Wilson's motion, the merits of his motion.
Well, let me ask you, because that confuses me. If we were to remand, what would happen in district court? The district court has said that there's a reason to be concerned about danger to the public. That's going to be the case regardless, isn't it? And it's just as insertable into 3553A as it is into 1B 1.13. So what is the purpose of the remand? The court's already made the factual findings it would need to make.
I mean, I think it's difficult to say what the district court would do today because the circumstances are quite different. For example, Mr. Wilson has served quite a bit more of his sentence, about 60 or 70% today. And I think that, there could be different analysis on the dangerousness finding if Mr. Wilson had demonstrated that in BOP custody, he had been a model inmate. So there's really no way to know what the circumstances in front of the district court would be today. And I think just on this order, the fact that there's so much unknown here gives us a reasonable likelihood that the district court would have come to a different conclusion. I would like to reserve the remainder of my time for rebuttal.
Good morning. May it please the court, Paul Farley for the government. This court's recent Hall decision, which we provide as a 28J, makes it clear that the district courts may deny compassionate release motions when any of the three prerequisites is lacking and do not need to address the others. So I can discuss the first and second requirements, but I'd like to start with the third one, the 3553A factors, because I think it's the shortest and surest route to resolving this appeal. The district court denied relief after a complete review of the motion on the merits and considering the 3553A factors, noted the defendant had served less than a third of his sentence, the criminal history and the nature of the instant offense, noting that despite 2 prior felony convictions, he was driving around the middle of the night with a dealer-level stash of drugs and 2 loaded guns, and that such a drastic reduction as he was seeking would neither reflect the seriousness of the instant offense nor promote respect for the law. And this, after the court had already varied downward by almost a year from the applicable guideline range when it imposed the sentence. The court was not required to do really anything beyond that. I think, as was pointed out, that if there's some ambiguity in the record here, we're on plain error, and sort of the tie goes to the district court. And Hall further said the judge didn't need to provide a lengthy explanation if the context in the record made clear she had a reasoned basis for her decision. And so we look at the whole record as the judge did. The judge said she undertook a complete review, which included the PSR's detailing of his criminal conduct over more than a quarter century with steadily escalating severity. And as the government explained, over 20 years, he had never demonstrated respect for the law or a willingness to take the lessons of a criminal conviction or punishment to heart to change his lifestyle. And so it seems very clear that the court made an independent 3553A finding based upon the entirety of the record. I point out that the motion here was denied by the same judge who had accepted the guilty plea, reviewed the objections to and approved the PSR, and imposed the original sentence. So she thoroughly understood this.
In the district court, did the government take the position that 1B 1.13 was binding on the district court judge?
Yes, Your Honor. Both parties took that position at the time.
Does that matter? Should that matter as part of our consideration?
I think it certainly matters this far. We know what the parties urged. I think it's clear that we don't know how the court accepted that. As this court recently said in Carr in the last couple of months, and I think as you pointed out in your questioning my opponent, Your Honor, the district court has the discretion to consider those application notes regardless of whether they're binding or not. In fact, Hall kind of re-underscored that, said it would hardly be an abuse of discretion for district court to look to the present policy statement for guidance. I think at most, though, what we could say is there was an assumption by certainly the parties that they applied, because we were still had not heard on McGee, for example. But let's assume for sake of argument that the district court did feel bound. This goes back to the Carolero Escobar case we filed as a 28J, where the court said the parties in the district court seem to have at least assumed that 1B 113 applied. I think that's probably where we find ourselves. But again, we're on plain error. And even if there was error, which was plain, the defendant can't meet the third prong of plain error because the error didn't affect the outcome of the motion. Why? Because the court had already expressly made an independent finding of the 3553A factors, didn't support the request. And that finding warranted denying the motion independent of any policy statement.
How do we know? How do we know, counsel, as Ms. Esser suggests, that the dangerousness conclusion under the second factor didn't bleed over into the 3553A analysis?
Your Honor, what we don't know one way or the other, and frankly, I think it's of no moment, because
it's of a moment. It's of a moment if you do what you just suggested, which is assume that it was plain error to consider the policy statement as binding, or we would assume that the court considered it as binding. Then if we're assuming that, then certainly we could also perhaps assume that it bled into the 3553A analysis. Or could we?
Your Honor, I would pick up on a point Judge Phillips made a few moments ago, which is the court has made its findings. It would consider his lengthy criminal history and the danger to the public, because protecting the public is a valid 3553A factor. And so I don't know how one could say, go back, make the same factual findings, but put dangerousness, the concept of dangerousness over here in your head, but go ahead and apply it in terms of protecting the public. I think that particularly in this area, there's a lot of overlap, right? There are medical concerns which could be considered as part of the fifth 3553A factors. Those are also in the policy statement. I don't think there's any meaningful way to really segregate out factually those kinds of considerations.
Could you also address, I don't think we discussed it in the opening argument here, but could you also address the argument that the appellant makes about the Wold case, where we had some language in there indicating that we said we're not saying that a court can deny a compassionate relief on the ground that release is not appropriate under 3553A if the court has not considered the facts allegedly establishing extraordinary and compelling reasons for the release. We made a distinction in that case between actually not having to determine the extraordinary and compelling reasons, but perhaps needing to consider them when deciding a 3553A or conducting a 3553A analysis. Do we have any evidence that the court here considered the alleged extraordinary and compelling circumstances when conducting the 3553A analysis?
There's nothing in the court's order that says that. But again, it is our position the court need not specifically say that. Certainly to date, this court's precedents haven't required courts to touch each and every little space or item in the analysis, nor do they have to write a lengthy opinion. I note in the Wold case that there were 3 defendants there. As to defendant Wold, the court said that COVID-19 might qualify. So didn't quite find that, but clearly had considered it. And in Sands, the government conceded it. And so
right,
the question really here is...
I'm sorry. I think in Wold, I think the court did specifically note that it wouldn't really have the issue because the 2 judges in those 2 cases had specifically mentioned the alleged extraordinary circumstances when deciding or conducting the 3553A analysis. And we don't have that here. And so I do see a distinction, and I guess I'm asking you, what do we make of that statement in Wold?
I think the court has to satisfy itself they were considered. I would say in Wold and Sands, those 2 defendants, there was only a clause. It wasn't even an entire sentence in the order referring to... I'm
not asking you about those 2 cases. I'm saying I think yes. The court did satisfy itself in those 2 cases that it had been considered. If we have to satisfy ourselves here that they have been considered, how do we do that from this order?
The only way, Your Honor, from this order that you can satisfy yourself is the court's opening statement that it undertook a complete review of the record, and the extraordinary and compelling circumstances were both addressed pretty extensively, both by the defendant and by the government. If the court wants to say that in this circuit, you actually have to say something in your order, like the examples in Wold, then a remand would be in order, because the court did not say, and I specifically considered the COVID-19 issue, which the defendant raised. But I think a complete review of the order under these circumstances suffices. If there are no further questions, I'm happy to relinquish the remainder of my time.
Thank you, counsel.
Thank you.
Thank you, Your Honor. I would like to briefly address this issue in Wold, because I think that was actually the focus of much of this briefing, was what was the effect of the fact that the district court had made no specific findings about the extraordinary and compelling circumstances. I think the fact that those were not mentioned anywhere in this order is another significant reason why under third prong, there's a reasonable probability that the district court's weighting of the factors may be different. Because, as this court noted in Wold, essentially it's if the 3553A factors are affected by the extraordinary and compelling circumstances presented by a defendant, especially as here where the government actually conceded that there were extraordinary and compelling circumstances, that should have weighed heavily in the 3553A analysis, but the court doesn't.
Counsel, can I interrupt you on that? I didn't understand your argument to be that somehow Wold in this dicta essentially was indicating that there's a requirement that the court explicitly state in its 3553A analysis that it's considering the extraordinary and compelling circumstances factors. Is that what you're arguing? And I don't think that's what Wold said.
I don't know whether it needs to be explicit or not. I think in this case, I don't think that we can say that it was considered at all, because the district court was using a legal standard in which the extraordinary and compelling circumstances are separate finding, and it didn't have any direction that the extraordinary and compelling circumstances would have factored into the 3553A analysis. And the fact that it made no finding at all on the extraordinary and compelling aspect of the case strongly suggests that it did not factor into the 3553A analysis. I see that I'm out of time, and I would ask that this court remand for reconsideration of Mr. Wilson's motion. Thank you.
Thank you both for your arguments. The case is submitted. Looks like we have everyone. The next case for consideration is United States versus Warren. It is docket 20-1436. And after this case, we'll take a 10-minute break before the next two. We are ready to hear your argument, Mr. Lee, when you're ready.
Good morning, Your Honors. Josh Lee for the appellant Johnny Warren. In this First Step Act case, the district court committed 3 separate errors in denying Mr. Warren's motion for reconsideration. The one I'd like to start with morning.
Could we start with whether we have jurisdiction over this? We've got case law that's problematic.
Yes, so I would say first, the relevant statutes, both the First Step Act and 3582C, do permit motions for reconsideration. But even if there is
neither one of them says anything about motions for reconsideration, do they?
That's right. And the silence preserves existing law. So it's just a inherent authority of the court that when the court has the power to decide an issue, that carries with it the power to reconsider.
Well, we have case law that says when you're looking at 3582C that we have 3 instances where we have jurisdiction to consider revising or amending a sentence. And one is compassionate release, one is it's specifically permitted by statute, and the other is the sentencing range has been lowered. Motion for reconsideration isn't considered. It isn't named in those 3. And if you look at some of our case law, it would suggest that that divests us of subject matter jurisdiction over this issue.
So what this court's cases say is that, yes, you have to fall within one of these categories in which sentence modification is permitted, but Mr. Warren does fall within one of those categories because Congress has said this is the sort of sentence and the sort of offender for which you're allowed to reduce the sentence. There's nothing in this court's case law or in the statute that says each individual procedure by which a court goes about administering a substantively available sentence reduction remedy has to be expressly permitted. So, for example, the statute doesn't expressly say that courts can consider a government's response to a motion. It doesn't expressly say that the court can consider a reply or hold an evidentiary hearing or hear an appeal. Those are procedures by which courts go about administering a substantively available sentence reduction remedy. And a motion for reconsideration is no different from that. The other thing I would want to say is that if motions for reconsideration were barred, and I don't think they are, that bar would not be jurisdictional. And I think there's 3 cases that show that. Green, May, and the one that the government discovered, my colleague was sharp enough to find this one, although I wasn't, which is the Third Circuit's decision in Hart, which is cited on page.
And I think you are absolutely right that there's a lot of compelling authority to suggest that we're dealing with a claims processing rule and not a jurisdictional issue. But the problem that we have is we have published authority that says otherwise.
So I don't think that it says otherwise with regard to this specific issue. There's an 11th Circuit case that I cite in my brief. And the 11th Circuit case says just because 3582C in general is jurisdictional, that does not make each individual procedural restriction from that statute jurisdictional. So for example, in the 11th Circuit case, they talked about the exhaustion requirement for compassionate release motions. And the 11th Circuit, just like this court, has said that 3582C in general is jurisdictional. But they said that doesn't mean that this specific exhaustion requirement in the compassionate release statute is jurisdictional. And the same thing is true here, that if 3582C is generally jurisdictional, that doesn't mean the specific case of a bar on motions for reconsideration, which I don't think exists, doesn't mean that that's jurisdictional.
All right, I don't want to waste any more of your time on it. I do think it's a interesting issue. So
yes. I think the problem is not jurisdiction. The problem is what the district court did with that jurisdiction. And the error I'd like to start with this morning is the district court's failure to consider the COVID-19 pandemic in its analysis. The district court refused to consider Mr. Warren's COVID-based arguments based on the notion that he could have raised them in his 2019 motion. But as everyone agrees, the COVID-19 pandemic did not even exist at the time. So he could not have raised it in his initial motion. And in fact, the proceedings on the initial motion were over before the COVID-19 virus had even been discovered yet. So the government admits that this was erroneous, but says that the error wouldn't have made a difference to the outcome. I submit that the government has not met its burden to prove that the error was harmless and that this court should vacate the judgment because it's better to know on remand than to guess on appeal, as this court has said.
Is there a reason that it had to be brought, that you had to bring it as part of the motion for reconsideration rather than just bringing a separate motion?
Okay, so while there is not a bar on motions for reconsideration, in my view, there is a bar in section 404C of the First Step Act on second motions. So second motions are subject to a claims processing bar. Motions for reconsideration are not, which is why this was brought in a motion for reconsideration.
But even on something new, like a pandemic that hadn't existed the first time around on a separate basis entirely than, say, crack cocaine disparity?
So first of all, new evidence and new facts is a totally ordinary basis for moving for reconsideration. That's recognized in the civil rules. It's recognized in this court's servants case. Now, in terms of a First Step Act being crack cocaine, Congress has recognized that Mr. Warren is eligible for a sentence reduction. And so the question then becomes whether the court should exercise its discretion to grant the sentence reduction. And it takes into account a totality of the circumstances in that analysis. And so COVID-19, to the extent that it bears on the 3553A factors, and it does, is a material consideration to whether the court grants a sentence reduction under the First Step Act.
And if I'm understanding correctly, you're suggesting that just the fact of COVID-19 in general should have been considered because he didn't have any specific risk factors or anything going here, did he?
That's right. The fact of the COVID-19 pandemic should be considered, and there's several reasons for that. A congregate living environment puts Mr. Warren at greater risk of contracting the illness, which posed a serious threat to his health. And he's done 18 months now of hard time, of time that's considerably more stressful and restrictive than the sentencing court contemplated at the time of the sentence. Now, we're not saying that the court would have to grant a sentence reduction based on those considerations. We're saying that the court may have granted a sentence reduction based on those considerations. In other words, it would be permissible for the court to take those into account. And courts have taken that into account in cases that I've cited in my brief. So the error is saying, I can't consider this because it could have been raised earlier. Then the question becomes, was it harmless?
Okay, before we go there, one of the issues is what else can the court consider? And the court ruled that your career offender argument, way too late to make it, that you didn't make it in your original motion. And in fact, all along, the defendant has admitted that he's a career offender. And now in a motion to reconsider, you're trying to raise this new argument, which isn't what a motion to reconsider is for. And you're trying to tell me that the parties can dictate to the court the legal standard for granting a motion to reconsider. And I have big problems with that. So you're going to have to explain to me why somehow the United States could tell the district court what the standard is for granting a motion to reconsider any more than it could tell us what the standard is for granting a petition for rehearing en banc.
Okay, the first thing I want to say is that this does not impact the COVID-19 argument that I just raised.
I understand.
So I think we would prevail regardless of that on the COVID-19 argument. On the career offender issue, the rules about motions for reconsideration are judicially created, finality protecting rules, and those sorts of rules are waivable. So these are court-created rules designed to protect the United States. And if the United States—
They're waivable by us. They're not waivable by the parties. I mean, that would be the same thing as saying we've got rules, internal rules on when we grant a petition for rehearing en banc. And you guys could get together and you could change the rules and say, we agree that it doesn't have to be an issue that's unique or unsettled or whatever, and that you will hear it en banc. And I am not buying that at all. This is not a procedural timeliness issue. This is what are the rules for when it is proper to grant a motion to reconsider.
I think that what it's analogous to is the plain error rule. So this court has developed standards and says we will only grant relief for an issue that was not raised below where these four considerations are met. But this court has clearly said that that's waivable. And the same thing is true here. So if the United States says we waive plain error review, the court reviews de novo. I would also say that I don't think that the issue of whether the reconsideration standards are waivable is necessary to decide the career offender issue. Because what the district court said is, I point to your motion for reconsideration and you are conceding the issue. And that was erroneous. Perhaps the court could decide I'm not going to consider this on reconsideration. But what the court said is not that. The court said you conceded this in your reconsideration motion. And that is separately an error of fact. And unless the court has further questions, I'd like to reserve the remainder of my time.
Well,
hello again, Paul Farley for the government. Starting with the jurisdictional question that Judge McHugh was concerned with, we recognize that there is 10th Circuit precedent controlling it regarding 3582 as jurisdictional. As you see from our supplemental briefs, we think that's probably erroneous, but there's nothing we can do about that here. And so taking the landscape as we think it is, the defendant can only prevail here if he convinces this court that the parties intended to waive the governing law applicable to motions to reconsider, that governing law can be waived, and that the court below was required to accept such a waiver. And underlying all this, of course, is the question of why it would be reversible error for a judge to apply the law applicable to motions for reconsideration to a document captioned motion for reconsideration. The government's waiver of procedural and timeliness bars waive just that, any procedural and timeliness bars. First and foremost, of course, the government waived the fact that the motion was almost 7 months too late. And as we're taking our position in the supplemental briefs, we were waiving any mandatory claim processing rules. But neither party said a word about purporting to waive the substantive law applicable to motions for reconsideration. And being very practical about it, district judges review many motions for reconsideration, both civil and criminal. And if the parties think that this one should be treated differently, they need to say so. A sentence saying de novo review or notwithstanding servants of Pericles would at least flag for the court what was going on, but that didn't happen here. So quite naturally, Judge Arguello disregarded the motion's untimeliness and other procedural bars and treated the motion as she would any other motion for reconsideration. And as we point out in our brief, the Nelson versus Albuquerque case from this court held that failure to apply servants of Pericles to a reconsideration motion is an abuse of discretion. So the judge quite sensibly applied the law that was applicable to the document in front of her. Moreover,
let me interrupt for just 1 second. I mean, the government did agree to a rather broad, open-ended waiver of any procedural or timeliness bars. I mean, that is a very broad waiver, isn't it? And so the argument is
it's broad.
The argument is that your failure to have raised it previously is a procedural argument, not a substantive one.
And again, I don't think that a fair reading of what the parties both wrote indicate that anybody said, and this is the law that we think you need to apply. And I don't think the judge erred in taking a motion to consider reconsideration where no one specifically said, oh, by the way, treat this de novo, and treating it as she did. But I would go further, Your Honor. Even if the parties had wanted to agree that the substantive law governing motions for reconsideration would apply here, they can't bind the court. This court explained this in the Gardner versus Galetka case in our brief. It is one thing to allow parties to forfeit claims, defenses, or lines of argument. It'd be quite another to allow parties to stipulate or bind us to application of incorrect legal standard. Here we are. The line here is between determining how to review an issue, which belongs to the court alone, and whether to review an issue, a matter over which litigants have some broad authority. Quite simply, as the Supreme Go ahead. I'm sorry.
Let me interrupt again. I mean, your opponent cites Wood versus Milliard from the Supreme Court and says there, the court said that this court could not resurrect a statute of limitations claim that had been waived by one of the parties.
Right. Statute of limitations is a defense. It's a defense. claims and defenses and arguments can be waived by the parties because they're sort of masters of their case. What they can't do is tell the court how it's going to apply its own law. Even the plain error example my worthy opponent raised, that is the court's rule. The parties cannot stipulate that we're going to have a different plain error rule. And let's make this easier. How about clear error? If there's a situation where facts are to be reviewed by clear error on appeal, can the parties stipulate to de novo review? I don't think so. I mean, this goes to the heart of the judicial function. It's as old as Marbury, right? It's emphatically the province and the duty of the judicial department to say what the law is. Issue preclusion, claim preclusion, res judicata, timeliness, or other kind of procedural defenses, yeah, the parties can waive that. But when it comes to what law governs the disposition of the matter in front of us, that belongs to the judiciary. That's why the parties argue the law to you, but we can't agree to it. We can't divest the court of its authority to determine the applicable law.
Did the ruling on the career offender designation, was that based on an error of the district judge in understanding what the defendant was arguing?
Not at all. And I can parse the chronology if you would like me to, but in sum, the district court was correct that as a matter of historical fact, the defendant had given up a challenge to his career offender status, both at his original sentencing in 2008 and in his original motion for relief. I mean, in fact, in the original motion for relief, the defendant argued that they were a career offender, but at a reduced range. And it was a career offender sentence for which he argued and which he received. And so the court is exactly correct that at those two earlier steps in the case, the defendant said, yes, I am indeed a career offender. And that was what the court was saying. The court wasn't saying that, oh, on reconsideration, you've conceded it. No, but when you stand before the judge in the original motion and say, I want a career offender sentence based upon an offense level of 34, that sounds like an invited error to me, Your Honor. I've asked you to give me this sentence, and by the way, that's the one you got. But the court also said, and this is at volume 1, page 390, even assuming for the sake of argument that the defendant is correct, the court need not ignore the facts of his prior crimes when deciding this motion. And then the court went through his history and the good plea deals he got, and sort of ended up. And again, this is at 391. The court found that even without the career offender classification, the sentencing court believed the defendant's sentence was appropriate at the time of his issue, and this court believes that the sentence remains appropriate today. So
was the court required to calculate the applicable guideline range today before reaching a conclusion about whether or not it was appropriate, the sentence?
Not under these circumstances, Your Honor. If the court had said, I want to give him a guideline sentence, they would have had to recalculate the guidelines. But what Brown tells us, and this has been reaffirmed by the Crooks decision more recently, the First Step Act allows a court to at least consider subsequent decisional law that clarifies, not amends, the related career offender provision at issue. All right, it allows, it's not required to. And here what we see is an alternative, after a fashion, alternative holding by the court. He said, first of all, I think you gave this up in 2008 and 2019, but independent of that, looking at your criminal history and everything else, I see no basis for changing the sentence based upon your history and your conduct.
Well, didn't Crooks say that a resentencing under the First Step Act necessarily requires a correct calculation of the guidelines range?
Well, Your Honor, my reading of Crooks is that the district court there thought it wasn't allowed to revisit the career offender designation. And Crooks says this twice at 997 F3rd at 1278 and 1279. He said the district court misunderstood the scope of its authority by concluding Crooks's career offender status was unreviewable. That's the error. It isn't committed under Brown to the discretion of the court under the circumstances. Now, could we find a case where it was an abuse of discretion? I think that's certainly possible, but not in a case like this where the court has said, listen, the sentence you got is the sentence you should have got because of all the things that are already in the record and which, and been detailed at some length. And so essentially, the court said, even if I assume you're right about the career offender sentence, the court says, assuming for sake of argument, defendant is correct. And then the court goes on and says, I give you this sentence anyway. So I think it's harmless.
Well, but in broad, there might be in United States versus Broadway, which is a very recent case from the circuit, we say that the defendant, that it requires the sentencing court to start from the correct hypothetical guidelines range when you're looking at whether they're entitled to a reduction, and that you're looking at that guideline range based on the law as it is now.
I understand. And I think if taking that language to its, unvarnished as it is squarely at odds with Brown and Crooks. And I think Brown and Crooks both say it's permissible, not required. We're going to look at the particular circumstances at play.
Well, in Brown said the First Step Act allows a district court to at least consider. But then in Crooks, we said it necessarily requires a correct calculation of the guideline range. And then in Broadway, which I think is the most recent one, we said it requires the sentencing court to start from the correct hypothetical guidelines range. If I'm reading those cases correctly, which obviously we'll take another look at, the court didn't do that here, did it?
The court did not do that, but I would say two things, Your Honor. First of all, if we have some sort of, let's say, discrepancy between Crooks and Brown and Broadway, I think, I'd have to look and see whether Brown or Broadway were earlier. I guess we would defer to the earlier precedent.
It's the earlier precedent, but Brown there is no conflict. Brown says you have to at least do this. So it doesn't, I don't see any conflict between these cases.
I would quote Brown at 974, 1139 to 40, that the act allows.
Will you give me the site again? I'm sorry. 974 what?
Sorry. 974 F3rd 1139 to 40 allows the district court at least consider the subsequent decisional law. Crooks says, quotes Brown and provide and at that precise same language, allows the district court to at least consider a defendant's claim that sentencing him as a career offender would be error. Okay, now
that's Crooks quoting Brown, but then later
that's Crooks.
Then later Crooks says that at 1278 that it necessarily requires a correct calculation. So obviously we need to take a hard look at our own precedent and find out where we are. But what we can agree on is if it was required, it wasn't done.
Yes, but I'm not. That's after we get through all the jurisdictional and claim processing and the ability to waive the standard of review. Right? I mean, you have to jump through several hurdles to get there.
Right.
I have 50 seconds. Just the passage out of Crooks that I would, if you're going to look at it at 1278, 997, 1278, the court said the district court reached this conclusion because it determined Crooks' designation as a career offender was unreviewable. Okay, so that's the context in which I'm reading Crooks, is that there was a district court error said, I cannot revisit the career offender thing. And I think that clearly was an error. And so hopefully you will give us some clarification.
But you're saying that it would be okay for the district court to say, I choose not to.
If the district court chooses to deny the reduction based upon other considerations such as a criminal history and dangerousness, if we want to use that word, protecting the public, they need not do that.
So do you think that the court at a minimum has to say, assuming, as the court did here, assuming that these predicates no longer would qualify for career offender, I still would have the same sentence? Or do you think the court could say, I get all of this career offender stuff every day and I'm not buying any of it, so you're out of luck?
I don't think a court could. I think it would be abuse of discretion that and say in each and every one of these cases, I will never refuse. I never will look at the career offender status, because I think that flies pretty close to being in the face of crooks. But so I think the fact that the court said, even assuming for the sake of argument that I give you that, it doesn't change anything. I think in this case, that pretty much settles it. I see I'm out of time. Thank you very much.
Thank you.
Thank you, Your Honor. I want to reemphasize that whether the reconsideration standard is waivable has no impact on Mr. Warren's COVID-19 argument. The district court erred by not considering the COVID-19 considerations raised by Mr. Warren, and that error was not harmless. The reason that error wasn't harmless is because Mr. Warren had a substantial case for a sentence reduction. So the COVID-19 concerns that he raised may have tipped the balance. The other thing I want to say about the waiver issue, so moving away from the COVID-19 argument, is that when the government is saying you deny reconsideration based on the restrictions on reconsideration, what it's saying is you should have raised this career offender argument before judgment. It's too late. You should have raised it in your original motion. But that's the same thing as procedural default, which is waivable. It's the same thing as statute of limitations, which is waivable. It's the same thing as res judicata. All of these are, you should have raised this argument earlier so it can't be considered. And this reconsideration restriction on raising new arguments that could have been raised earlier, it's just a finality protecting procedural defense, like all of the other procedural defenses that the court has said are waivable. The other reason you know it's waivable is because the reconsideration restrictions, like the ones I mentioned, are not jurisdictional. They're court-created rules and therefore not jurisdictional, and non-jurisdictional rules are waivable. Thank you, Your Honors, and for the reasons I've said, I'd ask that the court vacate and remand for the court to revisit Mr. Warren's motion.
Thank you both for your arguments. The case is submitted, and we will stand in recess for 10 minutes.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Looks like everybody's here. Good morning. The next case up is United States versus Lantis, docket 20-8031. Mr. Smith, when you're ready to go, please proceed.
Good morning. May it please the court. I'm Grant Smith with the Federal Public Defenders, and I represent Mark Lantis. We agree that the magistrate judge correctly cited the applicable recklessness standard. The error here is that there's sufficient record evidence to indicate that the magistrate did not go on to correctly apply that standard.
I thought you made it clear that you were not making a sufficiency of the evidence argument.
We aren't making a sufficiency of the evidence argument.
I thought that's what you just said. So
no, our argument is solely that the magistrate misapplied the applicable standard. And there's three pieces.
You're saying you use the phrase, there's sufficient evidence to say that he misapplied the standard, which is a little confusing, but I think that's.
I understand the confusion, and I mean record evidence. Looking at the record in this case, this court has reason to believe that the correct standard was misapplied. And the first indication that the magistrate misapplied the correct standard is the magistrate's silence in its analysis, its written analysis, determining and detailing that Mr. Lantis was guilty of the charged crime. The parties agree that in order to be guilty, Mr. Lantis had to be subjectively aware of the risk and consciously disregard that risk. However, nowhere in the court's written order and its analysis does it ever mention Mr. Lantis's subjective state of mind when he decided to go off trail and take what he thought was an easier route back to the road.
But this is a very odd posture, isn't it? You're conceding that there was substantial evidence. I don't know where that's coming from, but perhaps someone could.
There has been a fire alarm recorded in the building.
it's not here.
The building's here. Christine, do you need to go, Christine?
I'm gonna see if this is a drill, but there's a fire alarm that apparently just went off in the U.S. Attorney's Office building, the Dick Cheney building here in Casper.
Let's stop the clock.
Let's take a break.
I apologize.
Paul?
May I have your attention, please?
Paul.
Okay. I don't know if we have Paul. But what we're going to do is we're going to circle back after this is over and start over with 15 minutes for Mr. Smith. And so advise the clerk's office, Ms. Martins, when the situation is cured. We understand these things happen.
And get out if it's burning.
Yes. Thank you, Your Honors. I appreciate the court's courtesy.
There has been a fire alarm reported in the building.
All right, there. Okay.
So are we going to take the next case, or are we going to, just wait?
Let's wait.
Okay.
Let's wait. At least let's wait a couple of minutes or 3, 4. I never thought of that. If I would have been arguing and been getting too bad a time, I should have just hit a button that said fire alarm.
Paul, are you there?
I'm here, Judge.
So is it just the three of us right now, or?
No, all of counsel are on with us.
Okay.
Would you like me to move everyone out of the courtroom for a few minutes?
I think that makes sense. Yeah.
Okay.
So long as Ms. Martins can get in touch with you to say everything's good.
Ms. Martins, are you there?
I think she went to go.
She actually left the meeting, or looked like she did.
She's just muted and off camera.
Okay. All right.
So I'm going to put everyone into the waiting room, and including you all, judges, so I can speak to her.
Okay.
So I'll be back in just a moment.
Thank you.
Judges, we're trying to get in touch with Miss Martins right now to see when she's allowed to get back into her building. Judge Phillips, you're muted. Actually, all the judges are muted.
Do we want to go to the next argument? It's your choice, panel.
I think we may as well go to the next argument.
I think she may be a while. I don't think.
If they made her evacuate the building, which they do for us, you have to wait till they'll let you come back in. And so,
if counsel's available, they may be down the street drinking soda pops, thinking that the argument's going to last 30 minutes. Is the next case ready, Paul? Do you think, or
I'm sure they're knowing what happened. I'm sure they're probably ready to go.
Okay.
So we're moving to Peter Wold.
Peter Holdings.
Holding.
Okay.
Holding.
Peter D.
Let me bring all the counsel back in. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Maybe the other parties are gone.
Judge Phillips, if you'd like to hear the last case next, Peter D. Holdings versus Wold Oil, if counsel are on the call, if they please turn on their mics and cameras. Oh, Mr. Jorgensen, I'm going to send you a request to unmute yourself and turn your camera on.
I was trying to pull up the screen to do that.
Not a problem. You should have a request on your screen right now.
Okay.
All right. Good morning, counsel.
Good morning.
I always start off by saying these Zoom presentations go without a hitch, but we just had a little hitch, so we're taking you sooner than you might have thought. So sorry for any inconvenience to you, but the next case for hearing is Peter D. Holdings versus Wold Oil Properties. It is docket 20-8050. Counsel, when you're ready to begin, we're ready to hear you.
Thank you, Your Honors. Good morning to all of you and to my colleague, Mr. Klosterman. My name is David Jorgensen. I'm in Tulsa. I represent Peter D. Holdings, the plaintiff below. And I think it's important to just get out there that most of the underlying facts of the case, really all of the activities except for the very last one, which is an assignment that is very much an issue here. All the contract documents, all of the dealings, all of the activities concern two companies that are the predecessor of Peter D. Holdings. One is a company called Black Diamond Energy, Inc., which is a Wyoming incorporated company with its principal place in northern Wyoming, and a company called Black Diamond Energy of Delaware, which is a Delaware company. To maybe help ease this along, I'm going to refer to the Wyoming incorporated company as Wyoming and to the Delaware incorporated company as Delaware. I don't think there's any doubt in the record or any dispute amongst counsel or the district court for that matter that there is completely common ownership between those two companies. But that their relationship comes into play obviously in the district court's decision. This is a lengthy opinion, and there obviously were many issues in this case. I think it's fair to say that the trial court, the district court, Judge Rankin, made many alternative holdings. I guess is how I would characterize them, each of which was in favor of the defendants. All of those basically were legal claims, except there is a very important, we say, accounting claim. And again, Judge Rankin denied any accounting to any parties, and so ruled. So,
well, maybe I could focus you on the specific performance and the farm out agreement. And I guess my question is,
be happy to do that.
You had not commenced dewatering operations by the deadline. Is that correct?
Well, I think our evidence at trial was that it was commenced, and there was testimony to that effect. I think the defendant's point was, one, it wasn't complete, and two, to the extent there was a dispute in the record and the testimony with regard to whether even commencement of dewatering occurred, and they say, so the court must defer to the trial court's holding in that regard. But I think there is testimony in the record that, and dispute, frankly, about what the technical terminology even means.
Well, you haven't.
Was commenced, so.
You have a contract definition. Boy, I don't know what that, it sounds like I'm possessed, but you have a contract definition, don't you? So, don't we have to use that?
Well, I think you do, and I don't have committed to memory the individual testimony of Eric Koval or the defendant's witnesses who were basically for Wold Oil Properties employees.
But you have in your mind that the court made a credibility determination, right?
He said so. So I think the court said that. I'm not sure I understood. I'm not sure I understood why Judge Rankin made that ruling. I read it, and I just don't really know what's behind that.
Well, we don't.
Courts do it all the time, and the judge did it here, so that's just the way it is, right?
Sure. Oh, sure.
Let me cut ahead a little bit, unless I'm interrupting Judge McHugh.
Go ahead.
Okay, talking about the contract and the substantial performance, one thing I want to get your take on, because it's really not in the briefs, touch on it in the reply brief, is the statute of limitations ruling, where Judge Rankin said on page 40, note 28, that the 10-year statute of limitations had run by the time you filed your complaint on December 28, 2017. That's right. More than 10 years after you claimed that you were owed this additional 25%. That sounds pretty solid to me. Tell me why not.
Well, I would say this. To begin with, I think he makes that ruling twice. One, that Judge Rankin does, I think one is in the claim that relates specifically to conversion, which is really a separate claim. That's a small claim, dollar-wise, compared to the main claim. I think there is a sentence in the midst of the discussion about the assignment and the failure to assign that refers to limitations. I don't see that very well fleshed out by the court. Not that it isn't right, but I don't see that very well fleshed out. I would say this, if you take the very earliest moments when we say the assignments should have been made, more than 10 years, but at the same time, they owed us the assignments. And the us here is the Black Diamond companies that are the predecessor. They owed us the assignments, and they continue to be demanded. And every day that they didn't make them was a breach, right? In other words, they didn't suddenly not owe the assignments the day after the very earliest day when we would say we should have had them.
You say continued to make demands. You say continued to make demands, but the documents in the record don't support that.
But look at the fact that these parties entered into, and there's sort of three key agreements, I would say, and two very important instruments. But the three agreements are the original farm out agreement, these kind of amendatory and superseding agreement of October the 8th, 2008,
yes.
And then the joint operating agreement, which really superseded all of those and became the governing document. In all of those, the entire object of that, from Black Diamond's point of view, and I think the party's point of view, if you're fair about reading those documents carefully, was that we would finally get, the client, we would finally get our assignments. December of 17 is easily within 10 years of October of 08.
All right, one last follow-up.
Yeah,
one last follow-up, and then
Sure,
I need
sure.
to back up because I want everyone to have a chance to answer the question. Is it a coincidence that the termination of the farm out agreement is 12/28/07 and the complaint was filed on 12/28/2017 with a 10-year statute of limitations?
I don't actually know that. I think that's it's fair to assume. By the way, the original, I came into this case when it was about 2 years old. The original counsel, a guy named Mike Kaminsky, died in the course of the proceedings below. But I think it's a fair inference to say, look, this might be a drop in, and all of us lawyers do this all the time. If you see a date that you think is a trigger date, is a tolling date, then you better file. So I don't actually know that because by the time I came into the case, I think that issue had been raised. There had been motions to dismiss and other substantive motions that predated trial, but.
Okay, thank you. That answers my question on that.
Okay.
Appreciate it.
Yeah, sure.
So, Mr. Jorgensen, just focusing one more time on the statute of limitations.
Yes.
In order for your action not to be barred, we would have to conclude that the first time you knew or should have known you had a breach of contract claim was on December 28th, 2007, when Wold told BDE it considered all obligations ended.
Well, that being the case, they continue to hold out that those things will be done, and otherwise, how do you get an agreement on October the 8th of 2008 that includes that? And they said, well, and their position is, well, you breached that. Okay, you breached that, so you don't get it. But all of that, I'm just saying that all of that in the record and on both parties' documents and testimony, all of that continued to be in play to the point where they didn't even have a JOA until the fall of 2008. So at all times, my client thought they were entitled to those assignments and that they were being promised to them. And I think that's the critical.
Well, the district court ruled against you on that and made a factual finding that your witness was not credible, that you kept asking for the assignments, and that and we're bound by that credibility determination, right?
You are, but I don't see why the court can't look at objective facts.
This court is not a fact-finding court.
Well, no, but I understand that. But I'm just saying the record is there, credibility or non-credibility, just in the documents. I would direct the court to that October 8th agreement. I'll give you the exhibit number if I can find it here, but it's 23, I think, maybe. And ask how that agreement made any sense, and how did the joint operating agreement make any sense whatsoever? So we're going to operate properties that we don't even get? Doesn't make sense. And those aren't credibility issues, I don't think.
Well, operating is different than owning, right? I mean, they're two separate.
Well, it is, but and pardon the interruption. It is, but the way things work out there in the oil patch is, it's rare that you would see a company have operations that doesn't own any interest in the field. Almost always the operator. Remember, the Black Diamond was the operator on day one. The operations changed later, but they were the operator on day one. And normally there are cases where you have that. This isn't one of them. The operator is going to be a working interest owner, or in this case, what we call a beneficial owner, one that is entitled to, is expecting to receive assignments. It already owned 25%, by the way, but it all fits together in exactly the way that suggests that on the day that JOA was entered into, per the October 08 agreement, that ownership, that beneficial ownership, really already existed. It's like we were just waiting for, where are the actual physical assignments that can be recorded in the real estate record?
Counsel, can I switch up to ask about the conversion claim? It looked to me like on that claim, you didn't even challenge the district court's finding that you were not a real party in interest on that claim because you didn't own the assets. I didn't see any challenge to that, which means that we could affirm on that ground.
I'm sorry, I didn't quite hear the question.
On the conversion claim?
Yes.
It didn't appear to me that you even challenged on appeal the district court's real party and interest determination, including that you're not a real party in interest because you don't own the assets.
I didn't understand. I'm not sure I understand, but all we were saying on that issue is it was quite clear that I think this is actually undisputed that when Wold took over, they took possession of all that equipment and that there was no payment, even for a percentage interest in it. I think that's all we were saying, that the record was clear on that.
Okay.
If we were to agree that you did not substantially perform under the farm out agreement, would you agree with that you're not entitled to relief in the form of specific performance?
Well, yes, on that. But remember, I think what has been elided here, and I don't really even understand the district court's opinion in this regard, there's no doubt in the court's opinion and in its findings that we, the Black Diamond, originally purchased a 25%. And it's a field-wide interest. We own that 25%, and we asked for an accounting on that. Of course,
well, you were given monthly accountings, right? You were apprised all the time of the financials, and what you were told was the amount you owed was greater than any amount of revenues generated. You're 25%, correct?
That's what they said. It's
okay, and you waited 10 years to request an accounting, right?
Well, I would respectfully say those are two different things. The fact that someone, an operator and a successor operator in this case, sends you self-generated, self-serving statements in which they're penalizing you to the tune of 300%. Because you supposedly are a non-consenting party when you're the ones that actually drilled these wells. You drilled and completed them. You spent, by the court's by own finding.
Well, the court found you did not complete them, right? I mean, that's the issue. The court found you did not complete the wells.
He found that, yes.
Okay. Well, there was never, during your period when you were in charge, the operator, there was never any CBM generated from these wells, although people adjacent were in fact getting coal bed methane extracted, correct?
Yes, Mindy. All we're saying is you can't have a look at the case we cited, the Cookson case. Very similar, I think. And I'm sorry for going over. I just want to answer the question. We don't do these farm out agreements, and there are a million varieties of those that I would put all into the general category of drill to earn rights. You don't spend $1 million and substantially complete, even if you didn't fully dewater, and the other party can have a claim coming back about that, like, well, we're going to penalize you these dollars and that dollars, but you don't have a complete forfeiture. And I think Cookson says that supposed to drill a well every year, and they didn't do it. They didn't drill it. And the court said, well, yeah, but
they had a period of 5 years where they had to drill the wells, and they did drill and complete the wells. It just so happened that one of them didn't fall in a particular calendar year. It was slightly in the other year, so they had 2 in that year. And the court said the essence of the contract was met, and therefore there was substantial performance. Here, the court said the essence of the contract wasn't met because the essence of the contract was to, as quickly as possible, be able to extract coal bed methane from this pool that other people were also trying to access. So, and I'm sorry, Judge Phillips, for going over.
Oh, we have only 5 cases today, and this is a complex case, so we're fine. You can answer the question if
My question was, I see that it's very different here because the essence of the contract here was not met where it was in Crookston.
May I respond briefly? Or
yes, please.
As I read the Cookson case, the letter of the contract, and I think that's what substantial performance speaks against, is the draconian letter of the contract said drill a well every year and for 5 years. In 2 of those years, they drilled 0 wells. And yes, the court said, yeah, but they drilled more in other years. It's good enough. But remember, there was a plaintiff in that case that wanted relief. They wanted 2 more wells. They prayed for that from the court, and it was denied on the basis of substantial performance. So that's it.
All right. Thank you for your argument. Mr. Klosterman.
May it please the court. Scott Klosterman on behalf of the Appellees, Wold Oil Properties, LLC, and Chipcore, LLC. Appellant's briefing fails to identify what standard of review applies to the issues raised in this appeal. In an appeal from a bench trial, such as in this case, the district court's findings of fact are reviewed under the clearly erroneous standard, and its conclusions of law are reviewed under the abuse of discretion standard. Appellant's briefing fails to articulate how the district court's findings of fact are clearly erroneous, or how the district court's conclusions of law are an abuse of discretion. Instead, appellant simply urges a different interpretation of the evidence. However, in this case, the district court's bench or order on bench trial and its judgment is extremely well supported by the facts in this case, an analysis of those facts, and an application of the controlling law.
Let me ask you about one piece of those facts and the ruling, which is the real party and interest ruling. Not sure I understand the district court's ruling there on the claims apart from the conversion one, in that Peter D. received by assignment all of BDE's rights. And so why would that not include the right to sue on the claims that Peter D. is now suing on?
Your Honor, the assignment from from Black Diamond Energy to Peter D. in 2014 specifically states that is an assignment of its working interest.
Well, doesn't it? What about the word all? The word all is in that assignment.
And all of its working interest doesn't include any choses in action in regards to any contractual or equitable claims.
How do you know that? What do you rely on that? I mean, working interest is kind of a vague term. How do you know it doesn't include choses in action?
Because the case law, as we've cited in our brief, indicates that when you are making an assignment, you have to make an assignment with specificity and particularity so that the parties or others who are reading that can determine what is the subject matters that are being assigned. And here, it's very clear that the assignment is limited to its working interest. But Your Honors, in all respects, this issue of the real party in interest is in fact a complete red herring. And why is it a red herring? Because Judge Rankin addressed all of the plaintiff's claims on their merits. So the question of whether or not Peter D. was in fact the real party in interest as to all of these claims is not relevant to its ultimate determination that as a matter of law, all of the claims asserted were in fact insufficient to establish a basis for whether it was a breach of contract, whether it was specific performance, rescission, conversion. Judge Rankin decided all of those claims on its merits, and therefore the court really, it's not an issue, I believe, of significance here.
But isn't it one? Oh, please, after you.
I was just going to ask if you could explain for me the judicial estoppel ruling that the district court seemed to make as an additional alternative holding to the real party and interest conclusion. And you, in your brief, you discuss the judicial estoppel holding. You say it should be affirmed, but I'm pretty confused about what was the reason for that estoppel holding. It wasn't really clear why the court went there.
So, Your Honor, as you may recall in the appellant's opening brief, they essentially have argued that Black Diamond Energy and Black Diamond Energy of Delaware were in fact the same, and that they were one and the same entities, that they had the same ownership, the same operations, and that they were treated as such. Whereas in the case that was submitted to the Wyoming Supreme Court, there was in fact specific statements that, as it related to the claims with the Oil and Gas Commission, that those were separately owned and managed companies.
Right. I understood all that. I guess I'm trying to understand what the significance of its conclusion was in this case, that they were judicially stopped from making the contrary argument here.
I think it was just simply that they were not being allowed to take inconsistent positions in these two different courts, one in the Wyoming Supreme Court and before the Federal District Court in Wyoming. But I don't
Did it actually impact any of the conclusions is what I'm asking.
I don't believe so.
No one seems to be able to explain that.
I don't
Which is
believe.
why, and if it didn't, then you can't meet the third prong of judicial estoppel, which we shouldn't apply, that we very restrictively apply. So I don't think it matters, because I do agree it's a red herring, but I have some concerns, like Judge Moritz does, over that as judicial estoppel ruling. Can I turn your attention to unjust enrichment? You have a situation where the appellants did not meet their deadline in terms of dewatering these wells to get them ready for production. And it's, I think, 3.5 years before the letter goes out saying we're canceling the farm out agreement. And during this time, they're continuing to expend money and effort to try to develop those wells. Doesn't that sound a little bit like an a legitimate unjust enrichment claim?
Your Honor, to answer that question, you have to understand that the very essence of the farm out agreement is for purposes of developing the coal bed methane gas. And as part of that process, as the court may be aware, in any coal bed methane gas production, before you can actually produce gas, you have to dewater the coal seam. And that is a critical aspect of being able to bring these wells online and start producing. From the time that Black Diamond Energy started the commencement of drilling in 2003, at no time did they ever dewater any of these wells. In fact, they had done nothing to actually hook up these wells in order for them to be dewatered. And we know that fact because in the state of Wyoming, if a operator is going to produce any produced water, they have to report that to the Wyoming Oil and Gas Commission. And for all of these wells that are at issue, the first time that there was any dewatering of these wells occurred in 2009, after Wold had taken over as operator of these particular
That's
wells.
the premise of my question, is that they did not complete the wells, they did not dewater them, and you couldn't have production of CBM without dewatering. So there's a breach. They didn't meet the requirements in terms of their deadline under the farm out agreement. And my question is, why wait 3.5 years to tell them that we're not going to honor the obligations to give you an ownership interest in these wells, but we're going to let you keep trying to complete, even though we've already decided your completion is too late?
Your Honor, that assumes the facts that they were actually performing work to do further work to dewater these particular wells, and there's no evidence that they ever did that. The fact of the matter is that as a working interest owner, Wold, as well as other working interest owners, have many other properties of which they were concerned about, and really they had left it up to Black Diamond to do its work as indicated in the farm out agreement. And it was very specific about what their requirements were. The fact is that the delay as far as the termination didn't change the fact that they could no longer earn these additional interests because they didn't comply. They didn't.
So my question is, holdings no longer can get the interest in the wells because they didn't meet the deadline. But holding alleges it's continuing to do work for the benefit of Wold for another 3.5 years before it is informed, no matter how hard you keep working, you can't fix your breach. That's what I'm trying to get you to focus on.
And Your Honor, please consider that the work that is being done by Black Diamond would be for its own benefit, meaning it is a working interest owner already in 25, it has a 25% working interest ownership. So to the extent that it is performing work to further these wells, it's doing so for not only its own benefit, but all of the other working interest owners. So it's not as if it is not itself reaping some benefit because of any additional work. That doesn't change the fact that they could no longer earn because they failed to comply with the terms of the farm out agreement.
Is there a reason that you waited so long to advise them that the farm out was terminated?
The reason is simple, Your Honor, is that Wold was doing things in other fields throughout the country and throughout Wyoming that this was not of significance as far as the timing of when they issued their letter terminating them or terminating the farm out agreement. But certainly, if you look at the facts, we know that in 2008, the parties entered into a letter agreement whereby Black Diamond specifically acknowledged and accepted that all of the costs associated with the drilling and completion of those 14 wells would be their sole responsibility. Furthermore, by entering into the 2008 letter agreement, they acknowledged that they had no ability to earn any additional interest because the farm out had terminated. They did that because they understood that it would benefit them as a working interest owner. But that letter agreement was so that the parties clearly understood that there was no longer an ability by Black Diamond to earn any additional interest. And that simply, they were trying to resolve the issues with regards to payment, who would be paying for the first 14 wells, and then any additional drilling, who would be responsible for those costs.
But you're really not helping with the unfairness question. What's your answer to saying it took us 3.5 years to notify them is we were busy. But what if 2.5 years later, they had managed to complete the well? They were dewatering, they had the hookups ready. At that point, you still would have sent them a letter saying, sorry, but you're out of luck. You didn't make it all the way back in May of 2004?
No, Your Honor, it's simply that they didn't have the ability to earn the additional working interest.
Right.
They already had their.
Tell them that. You'd tell them, sorry, even though we didn't tell you that the farm out is terminated, and even though it's 2 years later and you've done the work of dewatering and setting up the apparatus to supply the coal bed methane, then you would still send them a letter that said you missed the target dates of the farm out, so you lose on your additional 25%.
Your Honor, I think this all assumes that Wold was in a position of forcing Black Diamond to do anything. That certainly was not the case. Whatever work that they decided that they wanted to do following the time that they should have completed that was at their own peril. The contract speaks for itself about what obligations they had, the timing for those obligations, and if they failed to comply with that, then they lost the right to earn these additional interests.
Why did you ever terminate it then? Sounds like it's self-terminating.
Why did Wold have to send a letter to that effect?
Yeah.
I don't believe that it was necessary, but it certainly put the Black Diamond on notice that was the position that Wold was taking. I think by its very terms, they had failed to comply with it. And because of that, they failed the ability, or they lost the opportunity to earn any additional interest.
The 25% ownership that Black Diamond, which is now Holdings, had in this area obligated them to expend a certain amount in terms of development, correct?
Yes, Your Honor. I think you're referring to the program deposit.
I think it's 25 million. Is that, am I right?
No, not, maybe it's 2.5 million.
Okay, maybe it's all right. But my question is, did they go over that during this 3.5 years?
Not that I'm aware of.
Okay.
And Your Honor, as it relates to the program deposit, that's really step 3 of this whole farm out agreement, meaning Black Diamond first had an initial obligation to drill 2 initial wells, and that had to be done by December 31st of 2003. If they satisfied that condition, then they could earn 25% working interest in the drill spacing unit around those wells. Step 2 was they could drill and complete 8 what we call additional wells by May 1st of 2004. And if they had done that, then they would earn a 25% working interest in the drill spacing unit around those wells.
But let me interrupt. All of these subsequent things were conditional on first qualifying for the first wells, correct? Because they all start with the phrase, it's something like, you know, if you got these initial wells, you have a right to try to earn more.
I see that I'm out of time. Can I answer that question, Your Honor?
Yes, please.
Yes, you are correct that all of these were conditioned precedents that were stepped on top of each other. And on behalf of the appellees, we would respectfully request that this court affirm the judgment of the district court. Thank you.
Welcome. Are there any other questions I should ask? We have some time. All right, Mr. Jorgensen, we hardly ever do this, and I'm going to hold you to it, but we'll give you 1 minute for rebuttal and 1 minute alone unless there are additional questions. Go ahead.
I would just emphasize on the accounting side of this that, again, not only were those 14 wells drilled substantially, when all was said and done, we drilled 31 wells out there. We haven't received a single nickel of revenue. Other owners, the operator itself, WOP, Wold Oil, they're paying themselves. They're paying the other owners in the field, and they're offsetting tremendous penalty amounts against us and sending us black box statements. There's something wrong there. There's just something wrong when you do that kind of work and you spend even the amount that the district court found we spent, and 10 production years later, more than 10 production years later in many cases, you haven't received a single nickel. Somebody needs to explain that. And I think that's what an accounting is. It's a piece of paper. It's not money. It's a piece of paper or a whole bunch of pieces of paper. So.
All right. Thank you both for your arguments. We appreciate your time today and the help that you've given us, and the case is submitted.
Thank you, Robert.
Paul, are you in the room or?
I am, Judge.
Okay, and as I said earlier, what we'll do is pretend that that Mr. Smith had not made such a hot argument that he'd set off the fire alarm. And we'll just instead just start as though we had not started before. Mr. Smith, you have 15 minutes. Please proceed when you're ready.
Thank you. May it please the court. Mr. Lantis' sole claim is that the magistrate judge misapplied the criminal recklessness standard. This court traditionally presumes that a magistrate knows and correctly applies the law. However, it'll step in and find error when the record gives this court reason to think that such a presumption is misplaced. There's 3 points in the record that should give this court ample reason to think that the magistrate misapplied the criminal recklessness standard. The first portion is the magistrate's written conclusions of law, in which the court never once analyzes or determines whether Mr. Lantis subjectively believed that going off trail carried a risk and that he consciously disregarded that risk.
Well, wait, I'm going to interrupt you there, because isn't one of the ways we show subjective knowledge is by the obviousness of the risk?
In some cases, the obviousness of a risk can demonstrate, or a jury or a fact finder could infer from the obviousness of a risk that the defendant was subjectively aware. However, those are the type of cases where
finding that the judge made, the magistrate judge made, went beyond just recklessness. The magistrate judge said, while not necessary to support a guilty verdict, it would appear that the risks and dangers were so obvious that his conduct rises to knowingly creating the risk. I mean, I have a hard time saying that the judge did not make a finding on recklessness when the judge specifically said it was so obvious that I could have found knowingly.
Well, there's a lot to unpack in that statement. And my first answer would be that you could interpret that statement as saying that this risk was so obvious that Mr. Lantis subjectively was aware of the risk. The problem there is that's the criminal recklessness standard. And the court prefaces that statement by saying, while not necessary to a finding of guilt, he uses this rhetorical flourish at the end of his conclusion to say it could rise to the level of knowing. But it appears that the court's citing the correct recklessness standard and saying that it's not necessary for a finding of guilt. That should be conclusive proof that the court is misunderstanding the criminal recklessness standard.
I don't follow your argument that you just made. Can you walk me through it again?
Sure. Recklessness requires the subjective knowledge of
Would you agree recklessness is an easier intent obligation to meet than knowingly?
Yeah, and this is where it gets confusing in that the line between the two is incredibly thin. But what's important to understand is that the distinction between the two doesn't rest on the obviousness of a risk. The distinction is the how likely it is that the risk will occur. So for knowingly, the risk or the harm has to be practically certain to occur. For recklessness, you just have to have a substantial risk that the harm will occur. So to say that,
I'm sorry, but if we're looking at how certain it was the risk would occur, the findings also say Mr. Lantis ensured he would be lost in the dark in an area of the park with a substantial blah, 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 blah. I mean, it looks to me like the court is meeting that part of your argument too. He ensured it, and it was so obvious we could meet a knowingly standard.
Well, to take the portion of the court's statement in isolation, saying it's so obvious it rises to knowing, that demonstrates that the court's misunderstanding the difference between reckless and knowing, because something doesn't become knowing by being more obvious. If the court had said these risks and dangers were so certain to occur that it was knowing, then yeah, that would make sense, and it would be proof that the court had correctly understood these standards.
Well,
But
why
just
does that
because-
matter? Why does that matter then? I mean, we know we don't need a knowing standard here. We need a reckless standard. And what you're saying is the court may have thought that the reckless standard was actually the knowing standard. So it found it was knowing, but at a minimum, it was very specific in finding that these risks and dangers were so obvious that his conduct rises to the knowing creation of the risk, which you're saying, okay, that means it rises to the reckless creation of the risk. So either way, the court made the findings it needs to make with respect to recklessness, didn't it?
No, that doesn't appear as part of its findings. It's a rhetorical flourish at the end of his findings that you've met the recklessness standard, and then says, while not necessary for a finding of guilt, it appears. Well, it doesn't have to appear. The government has to prove beyond a reasonable doubt that this was so obvious that Mr. Lantis knew of it. And there's another.
Let me interrupt again. You are now making an argument that the findings are inadequate, and this was a bench trial to a magistrate judge, and all the magistrate judge had to do, unless you made a motion for more, was to say guilty or not guilty. You had no right to any specific findings because you didn't make a motion under Federal Rule of Criminal Procedure Rule 23. So now you want to fly spec the findings to say they're not quite detailed enough, and I just don't think you get to do that from a bench trial.
Yeah, I absolutely agree. We do not get to do that. What we're pointing to is that the findings that the court did make is record proof or evidence, sorry to use that word, but it's indicative or indicia that the magistrate is not correctly applying the test. So you could picture the scenario where, the court doesn't consider the subjective knowledge of Mr. Lantis, and further says, my finding of guilt is predicated solely on the objective reasonableness of the risk. I mean, there would be no issue that the court was misapplying the test that it cited if it went on to say, no, all I'm doing is focusing on the objectiveness. So that's why we look to the record, is to see whether or not the court is faithfully applying the test that it articulated at the beginning. And the second
Well, would you agree with me if the court had said, I find you guilty in a one sentence order, that would be sufficient?
Absolutely sufficient. And I think that the cases in the guideline context help us in that they say a court has no obligation to make these findings. However, if they make these findings and it causes this court to think that it might be misapplying the standard, then it will be remanded, because this court's not going to turn a blind eye to a magistrate's sua sponte statements that demonstrate that it's not faithfully adhering to the criminal recklessness standard.
And what you're saying, it shows me that the court didn't faithfully apply the standard, is it didn't make a finding that said Mr. Lantis has extensive hiking experience and was well aware that going off trail in the middle of the backcountry of Yellowstone was highly likely to create a serious risk.
I don't think that's right, and that is not a the fact that he didn't make that finding is not per se reversible error. Well, the argument is that he writes this detailed order. He doesn't make that finding, even though it's a key component of the case. And that's indicative of the fact that the court misunderstood what it actually was required to apply. If there's no reason to think that the court would write this order and leave out a key part unless it was just misunderstood about what it actually had to find. In the second,
the real problem is the sufficiency of evidence thing, right? Because when you have to concede based on procedural history of the case that there was sufficient evidence, then that puts you in a position of having to say, sure, there was plenty of evidence there where the district court could have applied the correct legal standard, which it announced, but we don't like the way the wording of the magistrate's order is, and therefore please reverse. That's a tough sell. I don't know that I've seen a case like that one.
Well, I think it's important to realize that there's a difference between sufficient evidence and harmless error standard. So you could think of a comparable case in the jury instruction. You don't have to bring a simultaneous sufficiency of the evidence claim to say the jury was properly instructed and this was harmful error. You can raise that error while conceding that the evidence was sufficient, and this court will still reverse and remand and say, no, you have the right for the jury to properly consider each element of this claim. And if we can find that error, that erroneous instruction was harmful, we'll remand for the jury to do that. And that's what we're asking for here, that the court did not faithfully apply that test, and Mr. Lantis's constitutional rights were violated by not requiring the government or holding the government to its burden of proof for each element. And so that does go into the harmful or the harmlessness inquiry of whether or not this court can say beyond a reasonable doubt that this error did not influence the outcome of this case. And I don't think that can be said, especially when it's considered that all the parties accept that at the time Mr. Lantis left the trail, he thought it was going to be an easier and a more downhill route. He thought he was taking a shortcut. And so if that's accepted as true,
well, but it's not, because the district court didn't find that. The magistrate judge, we don't accept that as true. The magistrate judge obviously rejected that because he says, while the above may be considered reckless, any question in this regard is eliminated when Mr. Lantis left the marked trail, which would have returned him to the trailhead, and set off in the opposite direction, was through some of the most remote and rugged country in Yellowstone. So whatever Mr. Lantis argued to the magistrate judge, it is implicit in the ruling that the magistrate judge did not buy that.
I don't think that can be. I don't think that can be. Sorry, I'm sorry.
I'm sorry, go ahead.
Just push back in that I don't think it can be read as a functional rejection of Mr. Lantis's subjective beliefs, because in its finding of facts, it does reference Mr. Lantis's written statement and incorporates it into his finding of facts. The district court judge in its factual background says Mr. Lantis left the trail to avoid bears and thought the route was easier. The government in its own brief on appeal says that the route was harder than Mr. Lantis, or more difficult than Mr. Lantis thought it was going to be. And everyone appears to accept, including the magistrate, that Mr. Lantis subjectively held this belief that this was a shortcut. And if he did, then as a matter of law, he can't be found guilty of criminal recklessness.
Is that true? This really comes down to at what point was he reckless? And taking one step off of the trail, he probably wasn't reckless. But once he got a mile in, I think he made it about 7 miles. Once he got a mile in and then he saw, oh my word, there's a boulder field and fallen logs and everything else. Maybe I should head back to the trail. At that moment, was it reckless? I can see at that moment where it might be reckless, subjectively.
Right. It would become reckless at the moment that he was subjectively aware of the risk, that he was going to need a helicopter rescue, and then he powers onwards, despite the fact that he knows that this is going to cause a helicopter rescue. And the magistrate
doesn't return to the trail. That's the recklessness, right?
Well, I'm not sure, because then there's a subjective calculation of, is it more, if I honestly think that it's only a mile to the road from the boulder field, but 10 miles back to the trail, I think you're trying to mitigate your risk at that point. And the evidence is that's what Mr. Lantis thought. And the court does indeed credit that within its finding of facts. I'd like to reserve the remainder of my time for rebuttal.
Ms. Martins.
Thank you, Your Honor, and may it please the court. The United States is asking this court to affirm the conviction of Mr. Lantis and find that the district court correctly determined that the magistrate appropriately applied the criminal recklessness standard. And there are two main reasons for that. First, there's simply nothing wrong with the magistrate's findings of fact and conclusions of law. And second, properly limiting the case to the issues that's actually presented If there is an error in the findings of fact, this court may simply correct it, applying its general appellate standards. And those standards allow this court to affirm Mr. Lantis's conviction for any basis apparent on the record. And when we look specifically at findings of fact under Rule 23, what this court has said is that any reviewing appellate court may simply infer any finding that is necessary to support the judgment. And that's true even in complex cases. I would agree with Mr. Lantis that where findings are not required, but then a court offers findings that demonstrate some sort of misapplication of the law or an error was committed, that the court shouldn't turn a blind eye. But the findings here demonstrate that the court appropriately applied the correct criminal recklessness standard, and there's just simply no problem with this order.
At what point along that hike or even stepping off the trail was subjective recklessness proved?
So there's a few avenues to prove that subjective recklessness. What Mr. Lantis points us to in this order, I think it's most clear when he steps off that trail late in the day near the top of Mount Holmes. And as the magistrate...
One step off the trail?
Probably not that first step, but once you get a few feet off of that trail and leave that trail with the idea you're going to hike through some of the most rugged country in Yellowstone, that I think is where we find real recklessness.
Isn't it when you realize that you can't return to the trail without a rescue?
I don't think that it requires you to get so far out that you can't get back. I think that leaving the marked trail out in that portion of Yellowstone all by itself, and I don't think you have to get a significant distance even off of that marked trail to realize the dangers of what's gone on here.
It's not recklessness to his own safety. It's recklessness to the rescuers, the public harm.
Yes.
So if he doesn't take a coat and he doesn't have 3 Butterfinger bars in his back pocket or whatever else, he may be reckless as far as he's concerned, but it's irrelevant for the criminal charge, isn't it? The only thing that matters is at what point did he risk substantial harm to rescuers? And that's not taking 5 feet off of the trail.
I would agree with that, Your Honor, that certainly just the ordinary circumstances, you have to get a ways off the trail before somebody's going to have to rescue you. Now, the testimony below didn't talk in great detail about exactly what the trail looked like when you step off of it, but the country up there is awfully rugged. There are places along marked trails where they follow rock faces. A foot off the trail in one portion could be including that risk of rescue, whereas a quarter mile off the trail in another location would engender that risk of rescue.
But now you're doing something that I fault the magistrate for, which is the passage that's been read here where the magistrate says that he then made a difficult and dangerous trek into an area not seen by rangers seldom, and talks about the ruggedness and the difficulty of the terrain. Well, that's great if you're an expert and you know all about what that terrain looks like, and maybe the magistrate does, or maybe a ranger told the magistrate that later, but it's what is in the defendant's head about what the defendant is going to be challenging as far as getting to the destination that matters, isn't it? We don't care if it's rugged and so forth, at least to the point where he kept going when he could have gone back.
Well, certainly, I don't necessarily disagree with the court's point, but I think what the record and necessarily the summary in the magistrate's order tells us is that those things were obvious, and that obviousness supported his conscious understanding and disregard of that risk.
Well, he almost made it. He got within a couple of miles and the ranger was telling him, you've gotten through the hard part. You can make it. Take a nap. I'll meet you at the trail. And had he made it to the trail, there wouldn't have been a criminal charge, right?
Probably not, but not because he didn't create that risk of...
How could there possibly be? No rescuers would be endangered.
And that's where we would have to make sure that he finishes that last 2 miles without falling and breaking his leg or having some other mishap along the way that would cause him to need that rescue. But if he had made it out, he wouldn't have put those public folks in danger. And then, having only risked his own skin, that criminal citation would not have been appropriate. But that doesn't change the fact that his conduct was reckless all along. And recklessness doesn't hinge on his correct calculation of the risk or the fact that the risk ended up not coming to bear in a situation. His subjective understanding of that risk when he undertook the conduct, which was to leave the trail late in the day and head out into the backcountry, that's where we find the subjective understanding of the risks at play. And there's nothing wrong with the magistrate summarizing the objective facts before it to conclude that Mr. Lantis subjectively understood that there was a risk.
Unfortunately, that's not really what the magistrate did, though. It didn't really ever come to that conclusion that that's what it was relying on, were these objective factors for its subjective determination. We don't really know that, do we?
Well, I think when you look at the court's order, and what we find is that that's functionally what that's doing. So pages 31 and 32, volume 1 of the record, is where you'll find the magistrate laying out the correct legal standard for recklessness and then summarizing the facts before it in testimony. Mm-hmm. And what we look there at is that those facts in testimony are related to the objective testimony provided at the bench trial. And that's simply what the government must rely on in pretty much every criminal case, is a look at the objective observable circumstances in the world from which we infer a defendant's subjective intent, whether it's premeditation for homicide or recklessness for this disorderly conduct citation. And when we look at what has been said about recklessness, here the magistrate court relied on the model penal code and a couple of cases. Specifically, the parties have also relied on cases like Voisin and Farmer, where the United States Supreme Court summarizes that common law notion of recklessness. And even the United States Supreme Court in Farmer says that fact finders are entitled to rely on the obviousness of the risk in order to find that subjective component of recklessness. And that's simply
Is it enough here that the district court made that remark that the conduct, the dangers were so obvious that it was knowing, I guess is what the court said, but that the dangers were so obvious? Is that enough to kind of pull it all together? You throw all this out there and then you say, yep, it was so obvious that it was reckless? Or does there still have to be some tying of this defendant's experience? Or was he an experienced hiker? Was he a completely inexperienced hiker? How should he have known all these things? Or is it just obvious to anyone? Does that make sense?
Yes, Your Honor, I believe I understand. So first I would say yes. The fact that the magistrate court said that it was so obvious it was practically knowing, that's enough to tie it together for the purpose of the findings of fact. But secondly, there's even more in the record beyond the summary in the court's order to support its conclusion. And that's where we have Mr. Lantis undertaking specific actions that are only useful in terms of mitigating the risks of which he was aware. So the fact that he took items with him in the first place demonstrates that he understood that there is inherent risk on just being on the trail. And so we have things like a cell phone, radio, GPS. All of those things are only useful in case of communicating for emergencies, letting people know where you are. And so just being on the trail, he took those steps.
That seems the opposite of reckless. He is ensuring that he's not going to have to be rescued with those devices.
But when we're talking about whether he understood the dangers of being out in the wilderness, there's two questions here. One, whether it was reckless to leave the trail, and his understanding of the world around him. So when we're talking about it in terms of his understanding of the world around him, his actions geared toward risk mitigation certainly showed the understanding of the world around him. And furthermore, he called to tell people where he was going and what he was doing when he left the trail, yet again, underscoring his understanding of the world around him. There was no evidence in the record that Mr. Lantis was any less capable than any average person of understanding the risks around him. And in the absence of his testimony, when we look at that written statement that he gave the ranger, where he says he thought that he identified bear, scat, and fur on the trail, that even implies special knowledge of the wilderness. So when we're thinking about what's obvious to him and what's available in the record to support the magistrate's conclusion beyond its summary, which this court can look to affirm, there's certainly evidence that he subjectively understood the risks and maybe even had some special knowledge of the wilderness and its dangers. Now, the magistrate specifically points to him leaving the trail late in the day, virtually ensuring that he would be trying to traverse this difficult terrain that he understood was inherently risky just being on the trail in the dark.
Why does that matter? He spent the night in the wilderness, true, but that doesn't support a charge. No helicopter came.
Well, that keeps coming up, but all he has to do is create public alarm, right?
True.
So there doesn't have to be a helicopter rescue to violate this statute, does there?
I don't know that there necessarily does. I think that
if you have the rangers are all on notice that you got this guy out there and they're monitoring it and they have public alarm.
Yes.
I mean, is that a violation of this statute?
Certainly. And I think that when we talk about public alarm, the levels of alarm and whether it makes sense to, as a practical matter, pursue the citation, I don't know that the citation would have necessarily been pursued, but for the rescue and the extra dangers that it created as a practical matter, but as a legal matter.
It's really the restitution, isn't it? I mean, isn't this case really about restitution? They incurred costs from a private helicopter service to rescue Mr. Lantis, and this is all about trying to recoup those expenses. Realistic. I mean, if he walked out like Judge Phillips suggested, he made it that extra 2.3 miles and got on the paved trail, the designated trail. There might have been public alarm. Everybody might have been worried about him. Mm-hmm. But they wouldn't have expended any cash bringing in a helicopter. So it seems to me that's really what the focus is here, right?
I think as a practical matter, that's probably so, especially considering that Mr. Lantis spent no time in jail, paid no actual fine, was only sentenced to unsupervised probation and restitution. So
wasn't he banned from the park for 5 years also?
Yes. As part of his unsupervised probation, he was in fact banned from the park, which the magistrate caveated at sentencing that once the forest fund treasure was found, that Mr. Lantis could come back with a motion to remove that provision because that treasure hunt was supposedly his motivation for his adventures through the wilderness. But all of that said, the stakes in this case seem to be wrapped around that restitution order because it seems like the biggest thing.
Well, then is Judge Phillips correct that the time that we really ought to be looking at is when he recklessly created a situation that required a helicopter rescue?
I think that the magistrate focused on the decision to leave the trail, and there's no specific time in there that has to be proven because it's one of those on or about on this day kind of charges. So anywhere in there will work. And then when we look at that calculation of risk, I would go back to the idea that recklessness doesn't require Mr. Lantis to be right about that risk. Because remember, recklessness defined in opposition to intentional, purposeful, and knowing. Intentional is the conscious object. Knowing is practical certainty. You can have recklessness in relatively low probability situations. And for that, I would turn the court to Lefebvre on the substantive criminal law relied on by the U.S. Supreme Court and Farmer for those propositions and that explanation.
Well, let me ask you this. This is a weird hypothetical. So I'm hiking in Yellowstone and I feel the call of nature and I go off trail to find a secluded place to answer that call, at which point I'm attacked by a bear. Have I violated the statute?
I think it would depend on whether there's any evidence you knew there were bears in the area and the area.
Of course I know there's bears. Of course, I know there's bears in the area. I'm in Yellowstone. So that's it. All I have to know is that I'm on a trail in Yellowstone. Yellowstone has a lot of bears, and any time I go off the trail, I've violated the statute.
No, I don't think it goes that far, Your Honor. I think it would depend a little more on the specific circumstances and what the government could prove about what you knew and how you went off the trail.
What if it really were a shortcut and there were just a few logs and a few boulders, but he sprained his ankle and he would have been at the trail sooner, but now he needs a rescue? Violate regulation?
I would think so, Your Honor. If he's off the trail, bushwhacking through that part, even if it is a shortcut, it might have actually been shorter as a straight line than the trail, but that doesn't change the dangerousness of the conduct.
Okay, any other questions? Mr. Smith has some time left, I believe, and we'll give him a little extra since we took Ms. Martin's over.
Just want to briefly touch on the concept of reading this record as a sub silentio adoption of this theory that the risk was so obvious. The first being that this is not the type of risk that's subject to that sort of analysis. The understanding of this risk only comes with specialized knowledge. If you told a general member of the community, would you take a 4-mile trail path back to your car or 2 miles off trail, they're not going to know how hard it is to hike off trail and that that's the wrong choice to make, that you want to stay on the trail. The second problem is that, as Farmer v. Brennan makes clear, that the obviousness of a risk cannot be conclusive. So in this case, when there is evidence that they subjectively believe that that Mr. Lantis subjectively believed this was the less riskier option, it can only be rejected by the fact finder if the acts and conduct of the defendant make such a belief improbable. And it's hard to believe that the magistrate was fully understanding this complete test and making an uncredibility finding against Mr. Lantis without saying anything. For those reasons, we'd ask this court to vacate the judgment and remand for further proceedings.
Thank you both for your arguments. The case is submitted. What time do you want a telephone call?